Judgment in the matter of Secretary of State for Work and Pensions versus MM Scotland.
Lady Black will explain the judgment of the court.
Before I explain what this case is about, I should just say that the court has ordered that no one shall publish or reveal the name or address of the respondent who's the subject of the proceedings, or publish or reveal any information which would be likely to lead to the identification of the respondent or any member of his family in connection with these proceedings. This appeal relates to personal independence payment, sometimes shortened to PIP, which is a non-means tested allowance paid to certain people with long-term health problems or disability. The payment regime is set up by the Welfare Reform Act 2012 and the Social Security Personal Independence Payment Regulations 2013. Whether a person is entitled to PIP depends upon the degree to which his or her ability to live daily life is limited by his or her physical or mental condition. 10 daily living activities are examined in order to gauge the extent of a person's difficulties on a scale ranging from being able to carry out the activity unaided to being unable to do it at all. Points are allocated to the claimant ranging from 0, where the claimant can carry out the activity, to 12 at the other end of the scale of difficulty. If the claimant has a points total of at least 8, but less than 12, he or she is taken to have limited ability to carry out daily living activities and is entitled to PIP at the standard rate. If the total is 12 or more, the enhanced rate is payable. The daily living activity in question in this case is engaging with other people face-to-face, which is activity 9 in the table found in Part 2 of Schedule 1 to the 2013 regulations, which sets out the various activities which are relevant. Activity 9 is subdivided into 4 levels of ability, which are called descriptors. A person who can engage with other people unaided is covered by descriptor 9A and is allocated no points. A person who needs prompting to be able to engage with other people is covered by descriptor 9B and has 2 points. A person who needs social support to be able to engage with other people is covered by descriptor 9C and has 4 points. The principal issue in the present case is how to distinguish between descriptor 9B, where the person needs prompting, and descriptor 9C, where the person needs social support. For descriptor 9B, prompting means reminding, encouraging, or explaining by another person. The support given under descriptor 9C might also take the form of reminding, encouraging, or explaining. So what marks it out as social support within 9C rather than prompting within 9B? This court decides that the answer is to be found by paying close attention to the words of descriptor 9C, taken with the definition of social support, which for the purposes of Schedule 1 means support from a person trained or experienced in assisting people to engage in social situations. It has been accepted all along that this definition does not necessarily focus on a person with professional training or experience, and that a friend or family member who knows the claimant well and can offer support can be a relevantly trained or experienced person. But it will be possible to identify the 9C case because that claimant needs the support to come from someone who is trained or experienced in assisting engagement in social situations. Putting it another way, the support will only be effective if delivered by someone who is so trained or experienced. If the engagement would be made possible by input from someone who is not so trained or experienced, but rather is, say, merely a familiar or comforting presence, the claimant will not fall within 9C, but might fall within 9B. A subsidiary issue which this court has determined is whether assistance can only qualify as social support if it is given during the face-to-face engagement. Different claimants will be assisted by different forms of support, and what is effective might depend also upon the nature of the particular engagement. In these circumstances, it would be unhelpful to confine the scope of descriptor 9c to support which is contemporaneous with the engagement, unless that is dictated by the provision itself or by something in its legal context. This court finds nothing in the wording of descriptor 9c or in the definition of social support which limits matters in this way, nor is there anything elsewhere in the regulations to support a requirement that the support is contemporaneous. Accordingly, we decide that descriptor 9c is not in principle limited to social support during the face-to-face engagement. It will be a question of fact and degree in individual cases whether the particular support that a claimant requires is within the descriptor.
The court will now adjourn.